Hello, everyone. Welcome to today's Mid-Year Workforce Compliance Update webinar. My name is Chelsea Bedard. I'm the Senior Global Marketing Program Manager here at Workforce Software, an ADP company, and I will be your host for today's webinar. There will be some time left at the end for Q&A, so feel free to submit any questions as they come to mind, and I'll be queuing them up for our speakers at the end. I'm excited to turn it over to our main presenter, Paul Kramer. Paul is a Director of Compliance and brings extensive expertise in helping organizations navigate the ever-changing compliance landscape. Paul, I'll hand it over to you.
Thanks, Chelsea. Hello, everyone. My name is Paul Kramer, and I'm Workforce Software's Director of Compliance. Welcome to the presentation. Today's webinar has two aims. First, to provide you with information regarding new employer legal obligations in the United States and Canada that have taken effect in 2026 or will soon take effect. And second, to provide you with best practices to follow to help you stay compliant. Before beginning, however, let me tell you a little bit about me. As Compliance Director, my job includes staying current with workplace laws in the United States and Canada. Before joining Workforce Software, which is now an ADP company, I was in private practice specializing in helping employers work through employment issues in the areas of wage and hour laws, leave laws, scheduling, unions, and discrimination. My specialty, however, was employment litigation and giving legal advice, where I learned that compliance often turns on fine points of the law, so it's important for employers to know these laws. That's enough about me, but now let's take care of a quick housekeeping matter. Please remember that this presentation is for education only. It provides valuable information about the law, but it is not legal advice. You should consult an attorney or other professional when dealing with your employment circumstances. Now let's look at today's agenda. Okay, we'll start by discussing new laws in the United States, which seem to be arising every day. After that, we'll review new Canadian laws, followed by a discussion of best practices to follow to help you stay compliant. And finally, at the end, there'll be time for your questions. Let's begin with the United States, and we'll start in Illinois. First is Illinois Neonatal Intensive Care Leave, which took effect June 1st, 2026. Under this law, Illinois employers must provide leave to employees during their newborn baby stay in a neonatal intensive care unit. This leave applies to Illinois employers with 16 or more employees. Employees with 16 to 50 employees must provide up to 10 days of unpaid leave for a worker whose child is in NICU, and those with 51 or more employees must provide up to 20 days leave. Unlike the FMLA, NICU leave is provided to employees regardless of how many hours they have worked or their length of employment. Employees may take leave continuously or intermittently, but employers may require that leave be used in minimum increments of 2 hours. Employers may require verification of the NICU stay, but cannot require disclosure of the child's confidential medical information. Employers must maintain the worker's health insurance while on leave and reinstate the worker to the same or substantially equivalent position when their leave ends. Okay, for our next law, we'll be staying in Illinois. Effective January 1, 2006, Illinois amended its Nursing Mothers in the Workplace Act, adding protection for employees who need to express breast milk during the workday. This applies to all employers with more than 5 employees. The amendment clarifies that nursing breaks must be paid and that employers may not require employees to use paid leave or reduce their compensation for time spent expressing milk. Let's review some specifics of this law. First, employers must pay nursing employees for time used to express milk at their regular pay rate. They may not require employees to use paid time off, vacation, sick time, or other paid leave to cover time used for this reason. And employers may not reduce an employee's compensation in, in any form for time spent expressing milk. Employees may take reasonable break time as needed for up to 1 year after the child's birth, but nursing breaks may run concurrently with other breaks already provided by the employer. Employers must make reasonable efforts to provide a private location close to the employee's work area where milk can be expressed. The space, however, may not be a toilet stall. Employers are only exempt from providing this paid break time if doing so creates undue hardship as defined under the Illinois Human Rights Act. Next, we move to Virginia. Um, Virginia recently enacted a paid family and medical leave insurance program administered by the Virginia Employment Commission, also known as the VEC. It's funded through employer-employee payroll contributions. Employees may receive up to 12 weeks of paid leave per year, except for leave to seek safety services, which is limited to 4 weeks, with 80% weekly wage replacement subject to a cap tied to the state average weekly earnings. Employers may satisfy their paid leave obligation through a private plan, but it must be approved by the state. Payroll contributions begin April 1st, 2028, and employees can begin receiving benefits December 1st, 2028. Paid leave may be used for bonding with a child during the first year after the child's birth, adoption, or foster placement, caring for a family member with a serious health condition, the employee's own serious health condition, caring for an injured service member who is the employee's family member or next of kin, qualifying exigencies arising out of a family member's active military duty or call to active duty, and safety-related services for employees or covered family members due to domestic violence, sexual assault, or stalking. Paid family medical leave will run concurrently with federal FMLA leave if the leave is covered by both laws. Workers may take leave continuously, intermittently, or on a reduced schedule. Finally, employers must give written notice to employees about paid leave when they are hired, yearly, when they request leave, or when the employer knows they intend to take leave. Our next law will be staying in Virginia. Virginia passed a paid sick leave law granting coverage to all public and private employees in the state, a benefit previously limited to home health workers. The law requires employers to provide employees with 1 hour of paid sick leave for every 30 hours worked, with an annual accrual cap of 40 hours, all of which can be used within the year or carried over to the next year, although annual paid sick leave use is capped at 40 hours. The law applies to all employers regardless of size based on a phased-in schedule starting on July 1st, 2027 for employers with 50 or more employees, on January 1, 2028 for employers with 25 to 49 employees, and on January 1, 2029 for employers with 1 to 24 employees. In addition to leave for medical needs of the employee or their family member, the law allows victims of domestic abuse, sexual assault, or stalking to use paid sick leave to relocate, to get medical care or counseling, to seek legal advice, or to use victim services. This leave can also be used if the worker's family member is a victim. The law contains limited notice requirements where employees can request leave in nearly any way, including orally, and only need to include anticipated leave duration when possible. But employees are required to make a good faith effort to provide notice and to minimize workplace disruptions when the need for leave is foreseeable. The legislation allows employers to require notice of the need for sick leave, but only pursuant to a written policy previously distributed to the worker. For paid sick leave of 3 or more days, employers can require reasonable documentation to support the leave, including a doctor's note. The law prohibits employers from requiring disclosure of details of health information about an employee or their family member, or details of domestic violence, sexual assault, or stalking as a condition of taking leave. The legislation also requires transfer of accrued leave when employees are transferred within their company and requires workers to be allowed to retain accrued sick leave if the employer sells the business. The law does not automatically exclude employers with existing paid leave policies or collective bargaining agreements. Rather, only employers with policies or collective bargaining agreements that provide paid leave entitlements uh, sufficient to meet the minimum requirements of the law that may be used for the same reason and under the same conditions. Uh, uh, Only those people would be excused from providing additional leave. The law defines family member for purposes of care for a family member broadly to include an individual related by blood or affinity whose close association with an employee equals a family relationship. Next, we're going to go to Hawaii. Hawaii enacted a new law expanding the state's the state's family leave law to better support military families. Effective July 1st, 2026, in addition to leave for the birth or adoption of a child or caring for certain family members with a serious health condition, employees may take up to 4 weeks of family leave in a calendar year for a qualifying military exigency. Employees eligible for this leave include any person performing services for their employer for at least 6 consecutive months. A qualifying exigency refers to certain urgent or practical needs arising from a family member's active duty as set forth in the FMLA regulations, including short notice deployment, attendance at military events and related activities, childcare and school activities, financial and legal arrangements, counseling, rest and recuperation, post-deployment activities, parental leave, parental care, and any other activity an employer and employee agree is a qualifying exigency. Employees may take leave when the qualifying military exigency relates to active duty service by their family members, which include their child, spouse, reciprocal beneficiary, sibling, grandchild, or parent. When an employee requests family leave for a qualifying exigency, they must provide their employer with a copy of the relevant military orders necessitating the leave. Now we'll go to Arizona. September 12, 2026, Arizona is expanding its military leave law by broadening the reasons leave may be used. Beginning September 12th, Arizona is expanding its military leave to require leave for employees during any military training or active duty in compliance with competent military orders of the National Guard of Arizona or of any other state, or the United States Armed Forces Reserves. Formerly, the law limited military training leave to attend camps, maneuvers, formations, or army drills. In other words, Arizona broadened military leave protections by expanding eligibility for a leave of absence to training or active duty and struck references to limiting the leave to only specific training activities. Okay, next is Maine. Maine employees became eligible for Maine paid family and medical leave on May 1, 2026. This law grants employees up to 12 weeks of paid family and medical leave in a benefit year. It's run by Maine's Department of Labor and covers virtually all Maine workers with few exceptions, such as the federal government and employees of tribal governments. The program pays employees part of their average weekly wage equal to or less than 50% of the state average weekly wage at a rate of 90%, and the portion of their average weekly wage more than 50% of the state average weekly wage at a rate of 66%, up to a maximum of 100% of the average weekly wage. Employees covered by this law include all Maine workers earning at least 6 times the state average weekly wage during the base period, which is the first 4 of the last 5 completed calendar quarters before the leave begins. Employees may take leave to bond with the child during the first 12 months after birth or placement for adoption or foster care, to care for a family member with a serious health condition, to attend to a qualifying military exigency, to care for an injured family member who is a covered service member, to find safety from abuse or violence, for an employee's own serious health condition, and for any reason covered by Maine's family medical leave law, which includes the birth of an employee's child. The leave need not be used all at once, but can be taken intermittently or on a reduced schedule. Employees on leave have job protection if they have been employed for at least 120 consecutive days. Employers may substitute their own private plan instead of participating in the state's program, but these plans must confer the same or greater rights to employees as the state plan and must be approved by Maine's Department of Labor. Okay, next is New Jersey. The New Jersey Family Leave Act provides eligible employees with up to 12 weeks of unpaid leave in a 24-month period to care for a family member with a serious health condition or who has been isolated or quarantined because of suspected exposure to a communicable disease during a state of emergency, to bond with a child within 1 year of birth or placement for adoption or foster care, and to provide care or treatment for a child during a state of emergency if their school or place of care closes due to an epidemic of a communicable disease or other public health emergency. Effective July 17, 2026, the New Jersey Family Leave Act was amended to provide leave to more New Jersey workers as it was expanded to cover employers with 15 or more employees nationwide. Previously, it covered employers with 30 or more employees nationwide. Coverage limits will further drop to 10 employees on July 17, 2027, and to 5 employees on July 17, 2028. Also, to be eligible, an employee now must be employed for 3 months and have worked for the employer for 250 hours in the 12 months before the leave. Before, before the amendment, employees had to be employed for 12 months and have worked for 1,000 hours in the 12 months preceding the leave to be eligible. Finally, the law's amendments clarify situations where there could possibly be overlapping paid leave benefits. They provide that employees may choose whether to use New Jersey earned sick leave, temporary disability insurance, or family leave insurance. It is the employee's choice to use these paid benefits in an order benefiting them, but they cannot be used concurrently. Since temporary disability insurance and family leave insurance do not provide for a full wage replacement, the overlap prohibition keeps employees from using earned sick leave simultaneously to account for any shortfall. Okay, now let's go to New York. The New York City Department of Consumer and Worker Protection adopted final rules implementing the city's expanded Earned Safe and Sick Time Act, also referred to as ESTA, and which is now referred to in guidance as the Protective Time Off Law, or PTOL. The final rules took effect July 23, 2026, and clarify the law for New York City employers. Originally passed in 2014, ESTA requires New York City employers to provide paid or unpaid safe and sick leave in the following increments. Employers with 100 or more employees nationwide must provide up to 56 hours of paid time off per calendar year. Employers with 5 to 99 employees nationwide must provide up to 40 hours of paid time off per calendar year. And employers with fewer than 5 employees nationwide must grant up to 40 hours of unpaid time off per calendar year. This leave accrues at a rate of 1 hour for every 30 hours worked. Nevertheless, employers may front load the full leave amount at the start of the calendar year instead of using the accrual method. Unused accrued leave must carry over to the next calendar year, but employers may cap annual use at the applicable threshold, 40 or 56 hours, depending on the employer's size. Here are several key provisions from the PTOL clarified by the final rules. The final rules explain that protected time off under the PTOL has the same meaning as safe sick leave time under ESTA, but expands the reasons for taking leave to include workplace closings, or an employee's need to care for a child whose school or childcare closes due to a public disaster, including informal daycare such as babysitters, to care for a minor child or care recipient when the employee is the person's caregiver, pursuing subsistence benefits or housing, and to seek legal or social services help when a worker or family member is a workplace violence victim. The final rules clarify that employees are entitled to 32 hours of unpaid protected time off per calendar year, which is immediately available to workers upon hire. Employers are not required to carry over any unused portion of these 32 hours to the following calendar year. Employers may meet this obligation by providing some or all this time as paid time off. Notice of this time must be included in the employer's policies. The rules also clarify that protective time off is available only for employees working in New York City. Thus, employees who work both inside and outside the city may use unpaid protected time off only for the time they are scheduled to work in New York City. The final rules also state that employers must allow workers to use and receive pay for up to 20 hours of prenatal leave during any 52-week calendar period. Moreover, the final rules clarify that employers must track and maintain records of hours worked, protected time off accrued, and time off used each pay period for at least 3 years, as well as current balances of accrued or front-loaded protected time off. Additionally, employers must tell employees how much protected time off they accrued, used, and have available for use during each pay period. This information must appear on pay stubs or other documents provided to employees each pay period. Also, under the rules, employers must provide an updated notice of employee PTOL rights to workers in their primary languages when they begin employment or when their rights change. The updated notice must be displayed in an accessible and visible workplace area in English and in any other language spoken by employees. Employers with existing PTO, vacation, or personal day policies that meet or exceed PTOL requirements need not provide additional leave, provided the policy satisfies all PTOL obligations, including accrual, usage, and notice requirements. Penalties for failing to provide protected time off or paid prenatal leave include a $500 payment per employee per calendar year, and for failing to provide paid prenatal leave, 20 hours of paid prenatal leave will be added to the employee's leave balance. Now let's go to Chicago. The Chicago Department of Business Affairs and Consumer Protection issued final rules regarding its paid leave and paid sick and safe leave ordinance. The ordinance requires employers to provide covered employees with up to 40 hours of paid leave to be used for any reason and up to 40 hours of paid sick leave annually. The rules took effect June 1, 2026, and clarify certain situations. For example, the ordinance provides leave to covered employees. Covered employees are those physically present in the geographical boundaries of Chicago and who work at least 80 hours in any 120-day period. Remote workers and telecommuters who meet the definition of covered employees are covered by the ordinance, even if the employer is physically located outside the city. However, covered employees do not accrue paid leave or paid sick leave for hours not physically worked within the city's geographical boundaries, even if the employer is located in the city. Only hours worked in Chicago count toward the accrual of paid leave and paid sick leave. Second, the ordinance allows employees to take paid sick leave when their child's place of care unexpectedly closes. The new rules clarify that places of care not only include professional and formal organizations such as after school programs and child care centers, but also include informal caretaking arrangements such as paid babysitters and family or friends supervising children. Also, the updated rules authorize employers to maintain one combined bank of paid time off for paid leave and paid sick leave instead of having separate banks, as long as the employer allows workers to accrue up to 80 hours of paid time off and meets all other ordinance requirements, including accrual, front-loading leave, notice, and certification. Fourth, when an employee takes paid sick leave for reasons other than provided by the ordinance or otherwise abuses paid sick leave, the updated rules clarify that employees may be disciplined up to and including termination. Examples of potential abuse include patterns of taking paid sick leave, such as leave commonly adjacent to weekends, holidays, or vacation days, or leave taken on a day when a prior request to use a different type of leave was denied, or taking leave to avoid unpleasant duties. Before imposing discipline, however, employers should closely evaluate the leave circumstances to avoid noncompliance claims. The updated rules also confirm that joint employers are both individually and jointly responsible for complying with the ordinance. Additionally, if an employee is jointly employed by more than one employer, each employer must count that employee for purposes of coverage threshold defined in the ordinance, such as for payout obligations upon leaving employment. The updated rules define joint employment as when the essential terms and conditions of an employee's work are controlled by two or more entities, and that joint employment may occur when employers use temporary staffing agencies or professional employer organizations. Sixth, when employees become employed by a successor employer after acquisition or merger, the updated rules provide that employees must retain any accrued and unused paid leave and paid sick leave. Failure to comply may result in liability for both the original and successor employer. And finally, the updated rules provide that for non-exempt employees under the Fair Labor Standards Act, paid leave and paid sick leave time accrues based on all hours worked, including overtime. Exempt employees, however, may accrue paid leave and paid sick leave based on a 40-hour work week. Now let's go to Louisiana. Effective August 1st, 2026, the Louisiana Living Donor Paid Leave Protection Act created new rights for employees in Louisiana who serve as an organ or bone marrow donor. While the law established paid leave requirements for state employees, it also imposes new obligations on private employers to provide leave. Human organs mean all or part of a liver, pancreas, kidney, intestine, lung, or bone marrow. Under the Act, private employers with one or more employees must grant employees unpaid leave to serve as a human organ or bone marrow donor, provided the employee submits a request in writing. The length of the leave must be the amount of time requested by the employee or up to 30 consecutive calendar days, whichever applies. Although the law sets minimum leave requirements, employers can provide more leave than set forth in the law or provide paid leave instead of unpaid leave. The Act includes anti-retaliation provisions for using leave, making it unlawful for employers to discharge, demote, or suspend an employee, threaten or harass an employee, or discriminate against workers because they request or take donation leave. Now let's go to South Carolina. Um, in South Carolina, public and private South Carolina employers have a new legal obligation requiring them to provide leave for eligible employees serving as Civil Air Patrol members. Employees who are members of the Civil Air Patrol, which is the civilian auxiliary of the United States Air Force, are eligible for leave for qualifying reasons. Beginning October 1, 2026, employers must provide up to 30 days of leave per calendar year to participate in Civil Air Patrol emergency service operations, including mutual aid missions for other jurisdictions, and up to 10 days per calendar year for Civil Air Patrol training and proficiency activities, including training conducted by the Civil Air Patrol, the U.S. Air Force, the Federal Emergency Management Agency, or other emergency management organization. Because the leave accrues per calendar year, and because the Act takes effect October 1 of this year, it's possible an employee could be entitled to the full annual amount of leave in the last calendar quarter of 2026. Employers should also understand that leave requests for more than the specified number of days in the law may be covered if the leave falls into two different calendar years. For example, if an employee requests 16 days of training leave with 9 days to be taken in December 2026 and 7 days to be taken in January of 2027, the employer would have to grant the entire leave. And employers may voluntarily provide additional leave or allow employees to convert up to 5 days from one leave category to the other leave category when an employee has insufficient leave balance in one form of leave. The law differentiates between public and private employers regarding whether the leave is paid or unpaid. For public employers, the leave is paid. For private employers, the leave can be paid or unpaid at the employer's option. Unused leave does not carry over from year to year and is not payable upon separation from employment. The Act establishes several employee responsibilities. Employers must notify their employer of Civil Air Patrol membership within 30 days of hire. If the employee is a current Civil Air Patrol member, they must notify the employer by October 31 of this year. The employee must provide as much notice as possible for emergency deployment and provide at least 2 weeks notice for training leave. The employee must give notice of intent to return to work within 8 hours of leaving an emergency operation and return to work within 18 hours of leaving an emergency service operation or at the start of the next regular work day, whichever is later. The employee must periodically update the employer on the expected leave duration and the anticipated return date after an emergency operation and provide documentation verifying the participation when requested by the employer. Employers may deny Civil Air Patrol leave to employees required to respond to either the same or other simultaneous emergency service operation as a first responder, emergency manager, or other emergency services personnel for a local, state, or federal agency. Additionally, employers may deny leave for an employee designated as essential, but the law encourages employers to grant leave whenever the employee's absence would not create demonstrable operational harm. The Act provides significant employment protections. Employers generally may not require employees to exhaust vacation, pay time off, or other leave before using Civil Air Patrol leave, discontinue employee benefits during leave, refuse to restore an employee to the same or an equivalent position after the leave, absent legitimate reasons unrelated to the leave, or discharge, discipline, or otherwise discriminate against employees for exercising rights under the Act. All right, now let's discuss Canada. First, we're going to Manitoba. Manitoba is Canada's fifth largest province and is generally considered to be an employee-friendly province. Recently, Manitoba strengthened employee leave rights by passing legislation granting time off to workers who receive a child through adoption or surrogacy. Here are some key aspects of this law. First, the leave grants time off from work for employees to bond with a new child placed with them through adoption or surrogacy. A worker employed by an employer for at least 7 consecutive months is entitled to unpaid leave of up to 16 continuous weeks to fulfill responsibilities relating to child placement. Leave may begin no earlier than 6 weeks before the estimated placement date, or if placement occurs more than 6 weeks before the estimated date, no earlier than the actual placement date. And leave must end no later than 16 weeks after placement. Employees must give written notice of the need for leave at least 4 weeks before the leave begins, unless circumstances necessitate a shorter period. An employee failing to give proper notice or who gives the employer less notice than required is still entitled to leave the day the employee stops working. Upon the employer's request, an employee taking leave must, as soon as practicable, provide reasonable evidence of the employee's eligibility for leave. If during a leave the employee is notified that the placement will not occur, the employee may continue the leave for 2 weeks after the employee is informed. The employee must notify the employer of their return date as soon as practicable. And finally, an employee is entitled to only one leave for the placement of 2 or more children if the placement occurs within the same week. Okay, let's go to New Brunswick. The province of New Brunswick amended its Employment Standards Act by creating a new protective leave for employees unable to work due to serious illness or injury. Effective June 12, 2026, an employee continuously employed for more than 90 days may take up to 27 weeks of unpaid leave during any 52-week period. The leave must be taken in increments of at least 1 week. Employees must give notice of the anticipated start and end date of their leave, and employers may require certification from a healthcare supporting the leave. Employees returning from long-term illness and injury leave must be reinstated to their previous position or to a comparable position with no loss of pay or benefits. This legislation change in New Brunswick reflects the continued expansion of long-term illness and injury leave throughout Canada. Other Canadian provinces that recently established long-term injury or illness leaves or extended existing leaves to 27 weeks include British Columbia in 2025, Alberta in 2026, the Canadian federal government in 2022, Ontario in 2025, Manitoba in 2024, Newfoundland and Labrador 2024, Nova Scotia 2025, and Saskatchewan 2026. Okay, we'll go to Prince Edward Islands now. On June 30, 2026, several key changes to Prince Edward Island's Employment Standards Act took effect. First, an employee with at least 90 days of continuous employment with an employer is entitled to 27 weeks of unpaid medical leave in a year for reasons related to illness, injury, organ or tissue donation, gender affirming care, or other prescribed treatments. Second, an employee with at least 30 days of continuous service with an employer is entitled to 4 unpaid sick days per calendar year for illness or injury. Additionally, after a year of continuous employment, an employee is entitled to 1 paid sick day, which increases to 2 paid sick days after 2 years and 3 paid sick days after 3 or more years. An employer may only request a sick note to verify the employee's sick leave entitlement if the leave is for more than 5 or more consecutive days. Also, the standard number of work hours per week in Prince Edward Island was reduced from 48 hours to 44 hours, meaning employees are now eligible for overtime pay equal to 1.5 times the employee's regular wage rate for all hours worked exceeding 44. Industries exempt from the standard work week include highway construction and maintenance, uh, the seafood processing industry, the trucking industry, and the healthcare industry. Further, overtime in Prince Edward Island can now be calculated by averaging hours over 2 to 4 weeks if an employee and employer enter into a written agreement to do so. Finally, employers must provide a written schedule to employees at least 1 week before the work unless an unexpected schedule change occurs or due to an emergency. And employees must be provided with at least 8 hours of rest every 24-hour period, subject to certain qualifications, and split shifts must be completed within 12 hours of each other. All right, now let's quickly go to some best practices. Um, these will help you stay compliant. As you know, learning about new laws is difficult, but there are best practices you can follow to stay compliant and better manage your business. First, create a system to stay current with new employment laws wherever you have workers. You can stay current by regularly checking government websites, subscribing to legal newsletters, attending seminars and webinars, using HR groups and technology tools, or keeping in frequent touch with your attorneys, which unfortunately can be expensive. Also, consider conducting periodic compliance audits. Second, train your relevant staff in new laws. Training is integral in helping employees understand and abide by new laws, which is necessary for businesses to function properly and to avoid non-compliance claims. Third, apply the law, your policies, and your practices consistently. Consistent application is vital for fairness, compliance, and you must have it to have a positive work environment. It ensures workers are treated fairly, reduces the risk of discrimination claims, and promotes accountability. Inconsistent enforcement, on the other hand, leads to employee confusion, resentment, and a lack of trust of the employer. Fourth, keep accurate records of employee activities such as work hours, leave taken, break times, schedules, and discipline to guard against costly disputes and claims. And you'll be happy to have these written records if you ever are sued or have a claim filed against you. Fifth, update your employee policies and practices to comply with these new laws. And finally, consider implementing workforce software. Implementing software helps employers streamline operations, improve efficiency, reduce work, and improve employee management. This software offers many benefits such as better scheduling, time tracking, leave management, data accuracy, resulting in lower costs, better productivity, and increased compliance. And is truly a great time saver. Okay, I think now I'm going to pass it to Diane.
Hi, everyone. Thank you for joining us today. I hope you found this session valuable and are walking away with some great insights. My name is Diane Estes. I'm a delivery manager in our managed services department here at Workforce Software, an ADP company. Before we wrap up, I want to highlight a few next steps, especially if you're looking to take action on anything we've covered today. If you're already working with a managed services team here at Workforce, I encourage you to connect directly with your pod leader or whoever oversees your application. If you're not currently working using our managed services, no worries. We also offer support through our continuous care services team. The continuous care services team is here to help with additional needs, big or small. To make things easier and more flexible, we offer continuous care services packages, essentially blocks of hours you can purchase at a discounted rate and use however you need. Whether it's a few action items from today's presentation or some ongoing tasks you've had on the back burner, these packages are a great way to get support without committing to a long-term engagement. The best way to get started is to reach out to your account relationship manager. They can connect you with Christine Scott, delivery manager of our continuous care services team, or someone from our leadership team, whether in managed services or continuous care services, so we can find the right solution for your needs. If you have any questions, feel free to drop them in the chat, or again, speak with your pod leader or account relationship manager after today's session. Thank you for your time today. With that, I'll turn it back over to Chelsea.
Paul, Diane, thank you so much. That brings us to the end of our presentation. We've received some great questions throughout the webinar, so let's take a few minutes to address those now. And then also, if you have a question that we haven't covered, there's still time to submit through the Q&A. So, Paul, Diane, if you're ready, I have the first question for you, and that is, I believe this is to Paul. You mentioned that Alberta, Canada changed its long-term illness and injury leave in 2026. How was it changed?
In 2026, like other provinces, the maximum leave an employee in Alberta can take for long-term illness and injury leave was increased from 16 weeks per calendar year to 27 weeks per calendar year, which was done in order to comply with, to help assist with other federal benefits.
Thank you, Paul. The next question. We have an employee in Illinois whose child was discharged from the NICU and she wants to continue using NICU leave to care for the child at home. Is that covered?
No, it's actually not. Illinois neonatal intensive care leave must be used during the baby's stay in a neonatal intensive care unit. It is not offered if the child is already at home.
Thank you, Paul. And then one more question. What is a benefit year under Maine paid family medical leave?
An employee's benefit year under Maine's paid family medical leave is the 52-week period that starts on the Sunday before their leave begins. So it doesn't start on the day their leave begins, it starts on the Sunday before their leave begins.
Oh, very interesting. Thank you, Paul. And then that's all the questions we had for today. As always, thank you so much for joining us. Be on the lookout for a follow-up email from us with a link to today's presentation and some additional helpful information. We appreciate your participation, and please reach out to us at wfs@adp.com if you have any questions or want to dive deeper into any of the topics presented today. Have a great rest of your week. Take care, everyone.